Hello, everybody. My name is Gary Chodes, and I'll be your moderator today. Uh, this is a part of the Financial Poise webinar series on cybersecurity and data privacy. And in the slides, there's a section that provides a little summary of the series, and there's a slide that particularly refers to the episode we're in today. And speaking of the slides, today we're not going to go through them with any particularity. It's going to really be conversational amongst the panelists and the moderator, me. And here and there we will refer to some of the slides. So we're not going to be reading them specifically. The PowerPoint is handy, so you might want to look at it from time to time. And of course, you have it for your reference after the panel discussion. Today's panelists are Alex Sharp of Sharp Management Consulting. And Alex will give a little on his background.
All right, cool. So thanks, Gary. So Alex Sharp, sharp like a knife. Long time, been in this business for a very long time. I'm the practitioner on the panel. I've been a CIO, a CISO. I've run business units, and most of my work these days is around advising boards and senior leadership.
Great. And along with Alex, we have Katie Nadro of Levenfeld Pearlstein, and she'll give just a little bit on her background.
Hi, everyone. I'm a partner at Levenfeld Pearlstein. I practice in cybersecurity, data privacy, and artificial intelligence. Most of my practice is focused on helping businesses meet their compliance needs with the many, many laws we're going to talk about today, and keeping up to date on all the new laws and regulations that keep coming every single month.
Fantastic. As I said, my name is Gary Chodes. I'm the CEO of the National Law Review. I'm not a lawyer, but I have lots of experience working with lawyers over the years and as a business owner. And hopefully that makes me a good person to play act here as to what kinds of issues come up as a business owner in privacy. Just before we jump in, just a little bit about our sponsors. The webinar is a production of Financial Poise. And you can sign up for Financial Poise's weekly newsletters and other publications, including their website at financialpoise.com. The National Law Review, an affiliate of Financial Poise, is the co-producer of this webinar series as well. This is a live premiere of the webinar. You can submit your questions using our web portal. If you're watching this on demand or have any questions after the webinar, you can always send an email to info@financialpoise.com and just include your question and the name of the webinar episode, and we will do our best to give you a very, very smart answer. So with that, let's get this party started. Okay, so we're going to just start with some of the basic terminology and introduction in this privacy area. So, for example, we often lump together data security and privacy, maybe for the purposes of these kinds of panels and discussions, and they seem related, but are they really related, and what is the difference? Maybe we'll start with you, Katie.
Sure. So to start out with, data security, information security, cybersecurity, these are all technically different concepts, but we're going to kind of use them interchangeably today just because people colloquially use them sort of the same way. But at a very high level, data security is about all the practices, processes, procedures that a company generally, or any kind of organization, is going to take to protect data from being used or accessed in a way that the company doesn't want, either because it's a policy or it's a legal requirement to safeguard that data. A lot of times when we're talking about data security, we refer to what we call the CIA triad, which is confidentiality, availability, and integrity of data. So confidentiality is basically you want to keep your confidential data secure from being viewed, accessed, downloaded, stolen by somebody who's not supposed to have it. Integrity is about the actual trustworthiness of the data that you have. You want to make sure that your data is accurate, it's correct, it's not being tampered in any way that you're not expecting, so that you can rely on the data that you have to be what you need it to be. And then availability is you want the data to be available to the business units, the people that it needs to be available to. You don't want it to be, for example, locked up with ransomware or inaccessible because it's corrupt or any number of other ways that data can be not useful to you in your business. So to protect those three components of data, a company is going to take a lot of safeguards. It's going to take a lot of measures to protect that data and make sure that it's as useful and private and available to the business as it needs to be. You want to make sure that data is going to be protected when it's created, when it's transmitted anywhere, and then when it's stored so that you can access it and use it in the ways it's intended to be used.
Fantastic. Alex, if you could maybe weigh in a little bit on how would you describe the difference in your world as a CIO, CISO, lots of terms with C that for the technologists in companies. I've heard all those terms and more. What's your view in terms of data privacy and how is it related to security?
All right. So I think Katie, as usual, did a very nice job, very comprehensive job. So nothing to clarify there. Maybe one way to look at it is if you think about a spreadsheet, where down the one side you have customer names, individuals, and then across the columns you have different types of data elements. Privacy is when you look at the data from the perspective of the consumer. You look at the rows. Those are basically privacy issues, right? How do these things aggregate together to identify an individual, or are they data about an individual that it's the individual has the right to own and control? The columns tend to be traditional business issues. Right. So if you think about it like that, you really look at it, it's all about data governance, data strategy, data protection, but how the elements are associated and who you get in trouble with changes. In both instances, if you have a breach, and we'll talk about the difference between breaches and incidents as we move through the slides, but if you have a breach, one way or another, you're going to get in trouble with legislation, regulation, compliance. You're going to get in those kind of problems. But when you're dealing with privacy, you get into trouble with individual consumers, your customers. When you deal with data security, the column headings, you're really putting your business at risk and the risk of your stakeholders in jeopardy. So it's really truly just a different lens of the same data.
And
Great.
if I can just add on there, because this is why we need people like Alex around in your business. You can't maintain the privacy of your data without making sure you have good security procedures. If you fail on security, you will never meet your compliance obligations for privacy. Sometimes you might have some privacy issues, but if your underlying security structure is sound, you're going to be in a better position than if you have weaknesses in your security posture.
Yeah, and we have to highlight that. At the end of the day, privacy really builds on and provides a different lens to your security practices. You want to get in trouble? Treat them as separate entities. Work at them separately. They do have different nuances that have to be accounted for, but if you treat them as two separate efforts, you're going to waste a lot of time and money and you're going to end up in trouble somewhere down the road. Katie made an excellent point.
Great. And sometimes we hear this term cybersecurity. Can either of you just chime in on, is there a difference or is that just another way of saying the same thing?
All right. So officially, there is no definition of cybersecurity. It's effectively a colloquialism. The formal term is information security that came around in the 80s when we started merging. We moved out of the traditional world and we don't have to go through moats and castles and all that. But when we started combining network and computer security, we created this thing called information security. That's why there is a CISO, a Chief Information Security Officer. That's why you look in regulations and standards, you see words like InfoSec and information security. Sometimes they talk about information system security, but you don't see a Chief Cybersecurity Officer. It's really just a colloquial term. And for many of us who've been around for a while, we just kind of shrug our shoulders and say, okay, what's the next one?
Got it. Um, Katie, could you talk a little bit about what personally identifiable information is, and perhaps some of the distinctions between that and what we sometimes just refer to as confidential information?
Sure, absolutely. So today we're going to talk about actually a few different concepts between personally identifiable information, or PII, personal information or personal data, which is a broader category of data, and then other types of data that you want to protect, which could be sensitive or confidential. So confidential information is really just anything that is important to a business that you don't want publicly known. So if you're going to sign an NDA, a non-disclosure agreement with somebody, that's generally going to protect this giant swath of data or documents or trade secrets or other information that you might call confidential to your business. And that's really just information that you don't want the public or your competitors to know. It could be pricing strategies, it could be customer lists, it could be some know-how, some business goodwill, all these things that really are what make your business run. Those might be confidential. Personally identifiable information is information that by itself can be linked to a specific individual. And this is a term that's usually used in data breach statutes. Personally identifiable information is generally something like a first initial and a last name, or a first and last name linked with another identifier, such as a driver's license number, a social security number, date of birth, physical address, account number, medical information, health insurance information, things like that. We also have other terms of art that are used in different laws or regulations or policies. Some of those are personal information, which is covered by most broad data privacy laws now, like the California Consumer Privacy Act or the European General Data Protection Regulation. Those are any information about an identified or identifiable individual. So it could be as broad as, a first and last name with someone's height. Could be an IP address. It could be browsing habits on a particular shopping website that can be linked back to a person who lives at a certain address that is registered with an IP address. Personal information is very, very broad. Personally identifiable information is a subset of personal information, which is narrower. And then you can get into other categories of types of personal information, like sensitive personal information, which is a more highly regulated subset of personal information. That is something like your race, your ethnic origin, your religion, your religious or your health status, your diagnoses, your sexual orientation, sometimes citizenship, biometric information, which is very, very particular to a specific individual. Those are more sensitive data categories, which are more highly regulated. And then sometimes you can get even more granular with these types of categories, and you have something called either non-personally identifiable information or pseudonymous information, which is information where you've stripped out some of those identifiers. So, it's no longer Katie Nadro who works at Levenfeld Pearlstein in Chicago. It's a female attorney in the Midwestern area. It's just taking away some of the specificity of that data. So it's no longer tied to just one person. And then you have a final category, which is actually anonymous data, which I'm sure Alex will tell us no longer exists. And then there are similar types of anonymized data, which can be called de-identified data, which is probably as close to anonymous as you can get now that we have so much technology. We can dig into that a little bit later when we talk about AI. But anonymous data is really, you cannot tie it back to a specific individual. It is very hard technically to achieve that level of anonymity, just because there are so many data sets that exist in the world where you can kind of put the building blocks of different data sets back together to tie that information to a particular person. So people sometimes call that now de-identified data because it has stripped out identifying information, but you might work hard enough to tie it back to a particular person. That was a lot of categories. Sorry.
Right. Thanks for that color. It does seem like the overall message is that one has to be very careful with this and know which kind you have, or know which kind you're talking about.
And the other thing,
Definitely.
to throw in there is there is no single definition for any of this. There are federal laws that handle certain aspects, but for the most part, these definitions are regulated at the state level. And we have 54 jurisdictions in the US. We have the 50 states, Washington, D.C., and then the possessions. Every one of them is allowed to create their own definition. So this becomes very situation specific. And that's more of a caution than anything, because over time, as more and more states write data breach laws and privacy laws, and now biometric and AI laws, they are starting to look more and more like each other. But you have to be very conscious of which states you're dealing with.
Great. Speaking of legislation and the like, could Katie, could you perhaps talk a little bit about Graham-Leach-Bliley, that act, which I know provided a major framework when it was enacted on things like emails and telemarketing, and it impacts lots of our lives. Can you talk just a little bit about that?
Yeah, of course. And just to set the stage a little bit for a lot of what we're going to be talking about, the US doesn't have an overarching federal state or a federal data privacy law, as Alex mentioned. So what we have instead are different sectors that have enacted different regulations. So Graham-Leach-Bliley, for example, what we're going to start talking about here, it regulates financial industries. This is a federal law, so it regulates financial institutions across the country which meet the thresholds for this law. This is going to be companies like banks, like credit unions, like insurance companies, or other companies that engage in sort of lending in different areas of the financial sector. It is a much broader application than people necessarily think of just by its name. A financial institution is not just a bank. So it could apply to your business, even if you aren't necessarily aware that it does. But at a high level, Graham-Leach-Bliley requires financial institutions to protect the security and the confidentiality of their customers' non-public personal information, which is another definition of this type of information that we're going to throw at you. This is basically all the information that a financial institution collects about either potential or actual customers of it, and any financial institution which is overseen or which is within the scope of Graham-Leach-Bliley has to comply with the safeguards rule, which requires certain information security practices. And it also has to comply with the privacy rule, which is basically a notice that all of us get from our banks every year and none of us ever read, which says the bank is collecting these types of categories of data on you. It uses it for these purposes. It shares it with affiliates and non-affiliates. And here is your right to opt out of certain of those practices. I guarantee you, no one listening to this webinar right now has looked at one of those ever, unless they are actually practicing writing them. But so financial institutions are required to comply with both of these rules. And Graham-Leach-Bliley was really kind of the first broadly applicable privacy law that set the stage for these types of privacy notices. And it's important for data privacy laws in the United States because it provides an exemption for every single state privacy law at either the data level or the entity level. So for example, if you're a company that is subject to the California Consumer Privacy Act, if you are also regulated by the Graham-Leach-Bliley Act, the data within the scope of the Graham-Leach-Bliley Act is exempt from disclosure requirements under the California privacy law. There are also spin-offs from Graham Leach Bliley that are relevant for other financial institutions. So for example, the New York cybersecurity regulation kind of grew out of Graham Leach Bliley and imposes stricter obligations on financial institutions within New York. And that one is, like I said, more rigorous than Graham Leach Bliley.
And with New York's generally very active role in the regulation of financial institutions at large, are those rules under the New York Shield Act protecting New York consumers, New York financial institutions, or both?
Alex, do you want to take that one or you want me to swing first?
Why don't you swing first? Then
Fair enough. So
I'll dive in about this in NYDFS.
fair enough. So the Shield Act is protecting consumers in New York more broadly. So the New York Shield Act is kind of a data breach statute plus information security requirements, and it applies to businesses that have the personal information of New York residents. It requires each business that has this type of information to take certain technical, administrative, organizational security measures to protect that information. But it does provide for exemptions if you are already regulated by Graham Leach Bliley, HIPAA, or the New York Department of Financial Services cybersecurity regulation, which is an outgrowth of Graham Leach Bliley. Alex, do you want to add on to that?
Yeah, a couple of things. So excellent job as always, Katie. I really appreciate that. A couple of things. So first of all, on a practical level, the Shield Act is much more stringent than Graham Leach Bliley. Even though there's exemptions in there, you're going to find when you start working with your other requirements like NYDFS and all that, some other stuff gets snuck back in on you, right? So just because you're exempt because you're already covered by something else, you're still going to find additional requirements in the NYDFS that are privacy-like. And this goes back to the thing we were saying before about how privacy is really just a lens on your InfoSec, your cybersecurity program. Under NYDFS, there's probably three things to keep in mind. First and foremost, NYDFS provided a lot of clarity around breach reporting or incident reporting. And it basically comes down to if you have a ransomware incident, you have to report within 24 hours. And I'm just going to give you the broad strokes, right? Because there's a lot of details under here. And if you have any other type of breach, like, well, if you have any other type of cyber incident, you have to report within 72 hours. That is incredibly important for several reasons. Most notably is that that is becoming the standard for all reporting in the US and very consistent outside of the United States. 24 hours for ransomware, 72 hours for any other form of breach. The other key thing to remember with NYDFS, when NYDFS was in the process of being developed and before it was formalized and formally rolled out, a number of other states were also in the process of doing something similar. And what they did is they took a step back and said, let's wait for NYDFS, the state of New York, who tends to be very aggressive in this space and very forward leaning. Let's let them finish, and then we will use that as a template for everything else we do. So even if you're not in the state of New York or you're subject to it because you're covering New York State citizens, it it's in your best interest to look at what NYDFS is doing because either your state has most likely adopted it or it's somewhere in your future, right? So that just a couple little practical hints and tips.
Terrific. And certainly many of us have heard in the aftermath of the last financial crisis, Dodd-Frank was passed. Does Dodd-Frank have anything to do with uh, data privacy protection and those sorts of things, or is that just purely in Graham Leach Bliley?
Uh, Well, I guess there's two opinions here, right? And Katie and I have never talked about this. There's a legal view on it, there's a practical view. Practical view, no, right? It's it what's in there is just reinforcing what already exists. Um, you could argue it's a bigger hammer.
I think
Katie?
it's I think Dodd-Frank comes into play largely because with the creation of the Consumer Financial Protection Bureau, you have an additional regulator that's out there looking at disclosures to consumers, um, whether or not it's in an activist administration. And so with another regulator who has oversight of different components of these federal laws, then you have, several potential masters to answer to, and it's going to come to it with a lens of consumer protection, which is where a lot of the state level data privacy laws kind of originated from. They bubbled up from the idea of protecting consumers and giving them some transparency about the ways that their data is handled.
Yeah, and that's the bigger hammer I was talking about. But in practice, you have the same requirements. It's just the enforcement and how many headaches you're going to have. We could also argue that the OCC has a different role because of Dodd-Frank, but at the end of the day, from a practitioner standpoint, no change. You just have to do it. You just have more reason to do it.
Great, thanks for that clarification. Katie, could you perhaps give a little bit of color on what SEC regulations have to do with what I guess is what's referred to as like a cybersecurity rule, what the SEC has to say about that?
Definitely. And then I really want to hear Alex's opinion on this. Um, a few years ago, I think in 2023, the SEC issued a final rule that requires registrants, public companies, to disclose material cybersecurity incidents in their annual reporting. So the SEC was essentially requiring public companies to add um, a disclosure about whether they'd had a data breach or a significant cybersecurity event to the long disclosures that they provide investors to show whether their cybersecurity procedures, their entire information security program was sufficient or was a material risk to the company. And it's included as something that investors can consider when they're going to put money into a public company. The big scary thing that the cybersecurity rule added was that a public company now has to report a material cybersecurity event to the SEC within 4 days, which, as Alex mentioned, there are other legal regimes that require reporting within 72 hours, but 4 days is still a very tight timeline. And at the time, and still today, the cybersecurity rule is going to affect a much bigger swath of companies than even arguably the DFS regulation in New York. New York Department of Financial Services obviously regulates an enormous number of companies, right? A whole bunch of financial institutions are going to register in New York to do business. But even more companies are publicly traded companies, which are regulated by the SEC. So it had a very broad impact, and it has just had trickle down effects about what might be considered minimum information security standards. But Alex, I'd love to hear your thoughts on this.
Yeah, thank you, Katie. I think you did a great job of mapping it out as always. And in the spirit of full disclosure, um, I have some strong beliefs about this because I was part of the review team and I worked with several organizations on contributing to the SEC. So I have personal opinions on it that are going to come out. Um, to Katie's point, the reporting requirements are incredibly important. The only thing that's different from what we're seeing on the global trend, 24 hours, global trend is 24 hours, ransomware, 72 hours for all other incidents. The only difference we're seeing with the SEC rule is really two things. First of all, it has to be reported within an 8K. So it mandates the form, which essentially escalates or raises cyber to the same level as all other risks and materiality decisions in an organization. So cyber has moved from being at the kiddies table at the holiday dinner to the adult table, right? Cyber is now part of the business conversation. It's essential to the business. Those disclosures using the 8K are designed to help investors, right? Investors want transparency so we can make informed decisions. The other key piece in here is not, other than the format, is the 4-day window is the extra day, so you have it to produce it in the 8K, and it's consistent with about 90 years of history with SEC filings, right? So again, these numbers and the process in here is really designed to make it consistent. The 10K filing is part of the normal 10K you do every year. So again, cyber, infosec, privacy are now sitting at the adult table at the family dinner. The other key piece to this that fits in and often gets lost, particularly around handling incidents, is you have to make a materiality decision. And we won't go into what that all that entails, but every publicly traded company is required to have a policy on how to handle materiality. Is this incident, is the financial impact, is the business impact material to the business, right? Do we have to disclose accordingly? That has to be factored in. And by the nature of what we're talking about, the calculation fundamentally changes. Remember, historically, a lot of this stuff is based on tangible assets. We're now dealing with intangible assets. The other key piece that's in here, and I'm really glad to see this one's in here, is there is a national security element. So when an incident first occurs, the incident is going to be evaluated to determine if there's a national security or law enforcement impact so that the incident itself won't be immediately disclosed so we can deal with the law enforcement and national security aspects of it. So it was a little over a year ago, AT&T disclosed that they had an incident that wasn't reported, and it wasn't reported because there was some question about whether it was material or not. It didn't have to be reported, but the reporting was delayed, so the timing was told because law enforcement and the different elements of the international intelligence community could then pursue the perpetrators without tipping our hand, and that worked out in everyone's best interest. So it's really the three elements: the materiality, the reporting, and the law enforcement aspects.
Great. And I imagine with respect to the materiality standard, it would depend on um, all kinds of things that would be factual related to the type of breach it is and how things went down. So if it involved personally identifiable information, for example, if something like that was stolen, that might trigger something versus if it wasn't personally identifiable information involved.
Definitely.
Not an easy calculation in this space.
Yes, it would seem to be something where you'd need to have a lot of planning in advance and a very good playbook.
Here's a
Uh,
fa- here's a factoid for you. The Target breach, very famous Target breach in 2013. The last um, legal case resulting from that breach was finally settled in 2024. 11 years to resolve all the legal ramifications from one breach.
Amazing. And certainly the pressure of the 4-day requirement for the 8K filing adds to the intensity of the process. Great. Let's move on to a slightly different topic. Let's talk a little bit about healthcare and this term biometric privacy. Uh, Katie, could you shed some light on how HIPAA impacts this? That's an oldie but goodie. It's been around now for a number of decades, but how does HIPAA tie into all of this?
So that's exactly right. HIPAA is kind of the OG privacy rule that all of us know about. Um, basically,
I never thought the word OG and cybersecurity could be used in the same sentence, but
stick
I've
with
learned
me,
something
kid.
new.
Um, so everyone's heard of HIPAA because we've all had to sign HIPAA disclosures at our doctor office, and very, very, very few people actually understand what HIPAA covers. It doesn't cover nearly as much information as most people think. So HIPAA covers protected health information, which is really information that is created by a covered entity, which is a very, very narrow part of our healthcare system in the United States. It's basically doctors' offices, certain healthcare providers that accept health insurance, healthcare clearinghouses, et cetera. So it's much narrower than people think it is. And its privacy disclosures and security requirements are also narrower than a lot of people realize. It effectively has a privacy and a security component. So the privacy rule for HIPAA is, it sets limits and conditions about how your doctor's office, usually, or your hospital, can use and disclose your protected health information that comes about from treating you. You have to sign a form when you go to a new doctor that says, look, I've read your HIPAA policy, again, which no one reads. And it also allows you then later to have access to your health insurance records, or your health records rather. You can get a copy of it from your provider and you can try to get it corrected. Those are kind of the only rights you have for HIPAA privacy purposes. The security rule is similar to the Gramm-Leach-Bliley security rule that we talked about earlier. Covered entities under HIPAA have to take appropriate measures to secure your data to protect it against things like hacks. Protected health information is really, really valuable for hackers. And so the security rule is designed to protect it from external or internal intrusions onto that data. And this law is overseen by the Health and Human Services Department within the federal government. It is a federal law, but just narrower than most people think. It's not going to cover, for example, any information that is generated by your smartwatch, your phone, your period tracker, your pregnancy tracker, your wearable ring that tells you how much you slept last night. None of that is going to be covered by HIPAA because it's not related to any care that's conducted by a covered entity.
Yeah,
If your insurance company is asking for information from your healthcare provider, are they covered by this? And Alex, can you shed a little light on that?
well, I want to highlight what Katie said. And first of all, I think she gets tremendous credit for referring to HIPAA as OG. I just think that is, we have to go there and stay there. Highlighting what she mentioned is that HIPAA is much more focused than people realize. And the HIPAA disclosures that are actually put in front of most patients, that they're told to sign off on, are bloated. They actually are labeled as HIPAA, but they tend to cover a lot of items that really weren't intended to be part of HIPAA. So that's kind of informational. Um, and it was one other thing I wanted to mention that she brought in there. Oh yeah, and the other thing is you'll find that a lot of medical practitioners um, are a lot more confident in their understanding of HIPAA than they really should be. And I find a lot of times when I'm working with folks in the medical community, we have to reset their expectations about what HIPAA does and does not cover. Doesn't mean we need to protect the information. We have any less obligation to protect the data or the information. Just the drivers behind it changes and the reporting behind it changes. And it can be rather important depending on your situation. But I'm talking from the perspective of a practitioner that has lots of scar tissue, and there's a reason I have gray hair. So, yeah, just some cautions. Um, did we want to go on to biometrics?
Sure. Yeah, this is a good transition point. Why don't you talk a little bit about what we mean by biometric privacy and what issues come up there?
Yeah, so that's another thing Katie touched upon that I think is perfect timing here. So HIPAA does not directly, some people make the argument that indirectly it does, cover biometric information, but because biometrics are not really, it's not a clean thing. There's a lot of state and federal activity around what is biometric and what is not biometric. Basically, anything that's generated by a device, right? I mean, that's very simple terms. And let me give you a statistic and something that'll probably keep you up at night. A statistic is right now, the average person driving in a car, a modern car with all the sensors and whatever you have going on with your rings and your smartphone and all that, there is more data, medical data being collected about you when you're driving that car than there was in a hospital bed 10 years ago. So think about that for a second. That's how much data is being collected. If you have a CPAP machine, an Aura ring, smartphone, you use any of those portable heart monitors or blood pressure cuffs, this is all biometric data, right? And there's no agreement in how it's covered. So we're seeing a lot of stuff coming out. Some states are basically tagging it on and incorporating into privacy. Others are making it standalone. This is even extending, depending on the state. Illinois is famous for this. We're extending it that the sheer act of coming into the office every day and identifying yourself to like a time card machine is considered a biometric, right? So there's a lot of latitude in that space. Down those roads, and this kind of keeps people up at night when they start thinking about it, the most important data about any of us is not covered directly by any of these laws, and that's our DNA. So when you have your DNA sampled for medical reasons, which is kind of covered, or you use one of these genealogy sites or some other avenues, that is considered a different type of information and isn't necessarily covered by any of these laws. So now we're seeing the laws being expanded. We're seeing dedicated legislation specifically around DNA. And if you think about DNA for a second, it's not like losing a password. You can't change your DNA. You social security number can be changed. Your name can be changed. But if your DNA is changed, that's if you can find a way to do it, that's a bigger problem, right? So we're seeing some evolution in that space as well. Katie, do you
Alex,
have?
should we be potentially concerned that I understand that the assets of 23andMe may be sold? Like, what are some of the
Oh,
things that
they
I
were sold.
They were
know
sold.
are sold? So what should someone who used 23andMe this year or 10 years ago be worried about?
You should delete your data.
You should delete your data. You should delete your data, and you should delete your data. Those are the three recommendations.
So to just to touch on the 23andMe thing and to add a little gloss on biometric versus genetic data. The biometric data is going to be something that is your body. It's related to your body. And so it is very specific to you. It's going to be your facial recognition scan, like the geometry of your face, your fingerprint, your voice print, other things that are inherent to your body, and it can identify you in that way if it's tied to other identifiers. Genetic data is regulated by a whole bunch of different state statutes, and there's a Genetic Information Privacy Act, I think at the federal level as well. They all have different definitions about what counts as genetic data. Then there's some discussion about neural data, and this all was a big topic of discussion in the 23andMe bankruptcy, which, if anyone's heard about it, it's because everyone got notice that 23andMe was filing for bankruptcy, and it had this enormous data set, millions and millions of individuals who had their DNA samples on file with the company. And then a number of state attorneys general objected to the company attempting to sell that data within the bankruptcy context. And what's ironic is, had 23andMe gone through a normal sale process outside of bankruptcy, it would have attracted significantly less attention and gotten significantly less oversight from any regulator. It's only because it occurred within the context of a bankruptcy that anybody had an opportunity to come in and object to the sale of that data to a new entity when consumers might not have initially gotten notice of it. That case is fascinating, and it has a lot of implications for how we might consider these inherent components of our bodies. You can't change your DNA, you can't change your neural data, which is related to brain scans, and how it's going to be protected, especially if a company is going to sell it in the future, not necessarily, as part of its ordinary course of business, but as part of either an acquisition or in bankruptcy. So there's a ton of different state laws that regulate genetic data and biometric data. There's no one rule, and there's no one regulator looking out for people when it comes to that kind of sale. So if you are somebody who gave your DNA to 23andMe, I would recommend going and deleting it if you care at all about the sale. If you don't, maybe you'll get some additional benefit from the next company that owns it. But
And let me just throw one other point in, not to highlight the DNA thing too hard. The US federal government classifies DNA as a loss of DNA as a weapon of mass destruction. As far as our government's concerned in terms of um, defense and national security, the loss of DNA is on par with nuclear weapons. Just just throwing that out there.
That that's quite a statement.
Yeah,
Uh,
it's interesting. The person in charge of that I worked with on a few things, and about 3 minutes with him will make you question whether you ever want to ask him a question ever again. Just this topic.
Amazing. Maybe one last point on the 23andMe saga. Uh, Katie, Alex, maybe either of you can comment. Is there an absolute right to have your data about your DNA deleted? And if so, how do you even know that it's been done?
um, I'm going to give you a very lawyerly answer and say it depends. And it depends here on which state you live in, whether that right was afforded to you by a law or whether it was afforded to you by the grace of 23andMe through its policies that it posts on its website. So, to delve a little bit into the next topic that we're going to cover, consumer data privacy laws. Um, there are 19 different states that regulate that broader personal information category I talked about. And those different state laws afford individuals in those states the right to, among other things, delete their personal information. So if you were a 23andMe customer in, say, California, you could immediately go to the 23andMe website and assert your right to delete your personal data, which would include the DNA sample, any sort of analysis conducted on it, and any other data that 23andMe had collected from you. If you lived in Illinois, where there is no comprehensive data privacy law, you wouldn't have that right under a law. You might have that right under a genetic privacy law or under the privacy policy from 23andMe. A business can choose to offer its customers the right to delete their data voluntarily, right? But you might not have had the legal rights to delete that data.
Very interesting. Alex, anything else to add on that one?
No, I think Katie did a great job. The only thing to highlight is there is no clean answer.
Yeah, as to whether there was actually any deletion occurring.
There, okay, since we're going there, the other question is, what does delete mean? Right? So we could do a whole episode on this. And for for the sake of completeness, we probably should move on to the other topics.
Yes, we don't
Agreed.
want to get into the famous Bill Clinton, what's the meaning of the word the, or one of those kind of conversations. I'd like to skip ahead to something that's on everybody's mind, is in the news every day, which is AI. Um, how is this broad category of AI related to our, our episode today? What state and federal rules may or may not apply?
Katie, do you want to start?
Yes, that's a complicated question.
Yep.
Um, so with respect to privacy and security, AI, as we talk about it, is usually generative AI. which at a very high level, and I'm going to butcher this, Alex, so you can correct me in a minute. At a very high level, generative AI takes inputs. It has an underlying model that has been trained on a lot of data, right? Vast amounts of data. And it's either text, photos, images, videos, everything that's scraped from the internet or ingested through another data set. And then you can use that model and take inputs from users. So think of a chatbot. ChatGPT is the one most people are familiar with. A user will input a prompt. The model will take that prompt and spit out a new response, what we call output frequently, based on that model. So with that very rough definition, where we get into things like privacy or data security is if you have information about a person that comprises either the initial data set that the model was trained on, or it's within a prompt, or it's within some other information that's being input into the model, it can take that information, save it, synthesize it, and train from it, and then spit it out again in some new kind of content. So it has implications for individual data privacy purposes, and it can also have implications for security purposes because it can reach into systems and take confidential or other protected data and then train from it and theoretically spit it back out again to a different user who's not supposed to have access to that data. So with that extremely rough explanation, there are a lot of laws that might implicate AI or that can be used or interpreted to implicate AI, including a lot of data privacy laws. So I mentioned before that there are 19, give or take, one or two consumer data privacy laws. And I also mentioned that there are different consumer rights that are baked into those laws. In a lot of states, there's a right to know or to find out the reasoning behind something that's called automated decision making, which is similar to something that generative AI will do. So, for example, if you're a health insurance company and you have an algorithm out there that's supposed to find the cheapest method to treat asthma or something, you might have an individual patient who wants to get covered for a particular medication that treats asthma. And maybe the algorithm there, the AI, looks at that and says, no, we're not going to cover that because there's this cheaper way to do it. That's automated decision making that in certain states you might have the ability to challenge under one of these consumer data privacy laws. My example is not great because that might also be covered by HIPAA, which is going to have its own AI rules, but as a general matter, that's the kind of decision making that might be occurring with AI that could be regulated by data privacy laws. There's also consumer protection laws in every single state, which are supposed to protect consumers against, deceptive or unfair business practices. Those are going to be used, and in Colorado and Utah are already being used in a lot of ways to allow consumers to challenge decisions that are being made by AI in sensitive or legally significant contexts. So, for example, employment, creditworthiness decisions, lending decisions, things like that. If there's AI making a decision without appropriate human oversight, you might be running afoul of consumer protection laws in various states that could, regulate the use of automated decision making or AI to really affect people's lives without appropriate human oversight.
Yeah, fantastic answer. Let me highlight a couple of things from a practitioner standpoint. First and foremost, when it comes to AI, there the legislation and regulatory aspects are still evolving, and it's like we see every time a new technology disrupts, it takes a while for this to catch up. So we see a lot of states and even federal activities looking at creating dedicated laws or augmenting what they have now. So, hang on, it's going to be a bumpy ride for a while. So just keep that in mind. First and foremost, when you're dealing with any of these AI tools, if it was a bad idea before AI, it's a worse idea with AI. If you weren't allowed to upload sensitive information, or you had to anonymize it or de-identify it before you used it in an application, same holds true with AI. It's just a heightened concern. especially if you don't have what's known as a dedicated instance, which means any training and housing of the data is solely yours. It's not training somebody else's model. And any agreements where you're using anything that could be considered sensitive or private, be sure in your agreement it specifically states once the agreement is finished, you finished your contract, or upon direction, they are going to destroy the data in the instance. That's very, very important. The other thing you need to keep in mind is the risks around AI are largely, and you could argue numbers, whether it's 90 or 98%, it's driven by the use case. And the use cases includes the data. So you want to look at the use case that you have, like the ones Katie mentioned, to really drive your decisions. When it comes to specific privacy decisions, we're still trying to figure that out, and the legislation is trying to catch up. The related issue that often doesn't get talked about is bias. And bias is a funky term, it's got a funky definition. The best definition that's being adopted is actually out of ISO's global standards. The key there, and this is very important because people forget, you're not going to eliminate bias because the reality is none of us can last through the day without bias. The sheer fact that you're attending or viewing this shows a bias. What you need to do as an organization is determine your unwanted bias. And that's either because of legislation, regulation, corporate culture, your clients, what have you. Perfect example. Everybody talks about, oh, we can't make decisions based on gender. Well, if you're looking for new players of all women's basketball team, I bet you're looking at gender, right? And it's perfectly legitimate because of the use case, right? So there are reasons, right? You talk about you can't discriminate based on age. Well, if you're hiring a driver, they have to be old enough to get a driver's license. So you have to determine what is the unwanted bias. Hint and tips, there's 4 types of bias. We won't go into the details, but unwanted bias is the vast majority of what we deal with. And a lot of that has to do with how the models were trained and actually the structure of the model. So some free consulting for today.
Great. And Alex and Katie, as we're bringing today's webinar to conclusion, one last topic I just wanted to touch on. You mentioned the word unwanted, and this has been in the context of words or information. What about images? So we do hear now that the technology's out there where AI can take your image and then do something with it that would be unwanted. Sometimes that term deepfake has been used. Can you comment a little bit about that and how privacy intersects with this new ability to take your image and do something with it?
I'll leave the legal aspects of that to Katie, and I think I know what she's going to say, and then I'll give you the practical.
So there's a lot of different laws that might come into play with a deepfake. There are new AI laws, primarily in California right now and Colorado, that are going to regulate and prohibit the creation of deepfakes. They don't go into effect until, January of 2026, but there are existing laws out there that are supposed to protect against the use of this new technology to create deepfakes, especially if it's going to be for some sort of manipulation of individuals or manipulation of society. Creating deepfakes is actually considered a high risk use of AI, which is highly regulated in Colorado, will be in California. Texas has a new Responsible AI Governance Act that might come into play there. And then there's the EU AI Act, which mostly regulates EU, but it might trickle down to the US, just like the EU GDPR trickled down to our data privacy laws. There might be other laws that come into play there as well. The privacy component of it is if you give somebody your image and you say, according to your business's privacy policy, you're only supposed to use my data, including my likeness or my image, in certain ways, and then they don't, maybe you have a claim against the business for being deceptive under something like a consumer protection law, or maybe if there's a data privacy law that applies, you can have some sort of recourse to that there. Unfortunately, there's not a lot that an individual can do in these situations except be aware of what you're doing with your data, which is obviously something that I think a lot of, for example, parents are concerned about kids not necessarily knowing what's happening with the data that they're sending or storing or uploading to a lot of these different tools, which is a whole other scary topic.
Yeah, so Katie's dead on. Some of the issues we come into, believe it or not, have to do with intellectual property. What's the fair use? Also around what is your expectation of privacy? If you're walking down the street someday, somebody takes your picture, you don't know it, and then suddenly they use it as part of a deep fake, how are you harmed, right? There's there's arguments that abound that we haven't really resolved yet. We just haven't. So there's a lot going on. The only other thing I would add to that is it really depends on what your role and what your group is. So, for example, there's much more definition about what law enforcement or the federal government can do with images they've collected and how they can process them. There's more restrictions around that than individuals. Not to say that law enforcement can create a deep fake, but they are prohibited for doing things like what do they call it? Predictive policing, right?
Which is like real-time facial recognition.
Yeah, yeah. So there's things like that. And I do want to highlight, Katie brought up something very, very important when it comes to AI. There's two things to be very mindful of: the EU AI Act and ISO 42001. You'll find that everything going on globally around AI legislation, regulation, and standards are keying off of those two documents in the same way we saw GDPR affecting the US, we've seen, other global standards affecting. Doesn't mean you have to comply with producing the certain documents and all that for compliance or demonstrating, to your regulatory body. But the structures that are in those two documents are where we're seeing AI going. The big thing about the EU AI Act is they stack rank by use case, risk by use case, and you have to map controls to it. And 42001 establishes your AI governance program. So I would use those as the basis and watch what comes out of everything that comes out of ISO and EU is what the US is keying off of.
Very interesting. And even if the ISO standard is developed in Europe, it could end up still being something that the US regulators turn to.
Yeah, so that's an interesting about the ISO standards. ISO is actually commissioned by the United Nations, so by definition, it's global, even though we think of it as European.
But
Interesting.
But if you think about a giant company, for example, that has operations in Europe and the US, if it's already having to adhere to these stricter standards that come out of Europe or other global locations, the chances are that it might be operationally difficult to then have a lower standard in the US. So frequently you see companies adopting the more stringent standard just because it makes their lives easier. And so, practically speaking, you end up with the EU like standard coming into play in the US anyway for certain companies, and then they trickle that down through their contract parties.
Yeah, and then the only thing they do in the US is they don't worry about checking all the regulatory boxes. Like without going into details, ISO 42001 requires a third type of assessment particular to AI, which you see in outside of Europe where it's not mandated. Organizations are adopting and they're going, if we move into Europe, we'll worry about producing this other assessment, right? Because nobody wants another assessment. We have enough of them.
Great. Okay. Well, I think we're reaching the end of our webinar today. Um, Thank you for joining us today for another educational production by Financial Poise. Look for Financial Poise webinars wherever fine CLE webinars are sold. Thank you very much, everybody.
Thank you.
Thanks, everyone.
Bye bye.